Hi, and welcome to this presentation on the criminal appeals process for Professor Eric Muller's Criminal Procedure Adjudication class at UNC School of Law. This is a presentation that's going to focus in particular on the harmless error doctrine that appeals courts use across the United States in criminal cases. Most of what we've studied this semester have been rules of adjudication taking place in the trial courts. So we've been looking at constitutional rules, statutory rules, rules of procedure that are in procedural codes like the Federal Rules of Criminal Procedure, judge-made rules. All of these have been rules of adjudication that have been taking place in trial courts. But the adjudication process in the criminal context can continue past the entry of a judgment and of conviction and sentence in the trial court up to an appeals court. An appeals court, as you know, is a very different kind of court from a trial court. It serves different functions. It serves different values. And so our goal is to try to figure out what's going on and what ought to go on in the criminal adjudication process in an appeals court as distinguished from a trial court. In an appeals court, there are two distinct questions in a criminal case that are often blended together, and you really have to work to keep them separately. One of the things that the appeals court is trying to do, the first thing it needs to do, is to figure out whether some kind of error occurred in the trial court. Did the defendant suffer a violation of some kind of right, a constitutional right, a statutory right, a right arising under the rules of evidence or under a rule of criminal procedure, and so on? Then, after the court has decided whether some kind of error took place, it then needs to undertake a separate inquiry into what, if anything, to do about it. So error and remedy are two distinct questions in the appeals court. Now, sometimes those two questions do collapse into one or even disappear entirely. Brady versus Maryland, you'll recall, which was about the obligation of a prosecutor to turn over exculpatory information. The question of whether there was an error includes as a piece of the test whether there was a likely impact on the verdict. So in order for an appeals court to conclude that there was a Brady error, it needs to conclude that there was an impact on the verdict or a likely impact on the verdict, and therefore the question of what the remedy for that ought to be flows pretty naturally. A conviction is going to need to be reversed. We talked very briefly, and I made a presentation for you that you watched online about the right to a speedy trial. Well, if a prosecutor has dragged on for 25 years between the moment of an indictment and the moment when the trial begins, and the defendant's convicted and then appeals that conviction, maintaining that that duration of time violated the defendant's right to speedy trial under the Constitution, it's pretty clear that if 25 years is an error, and it likely would be, the question of what the remedy ought to be really flows directly from that. The only way of making the defendant whole is to reverse the conviction. And we also saw how errors that occur in the grand jury actually, for the most part, disappear in the appeals process, because any error that occurs in the grand jury, if it's followed by a trial that was brought to completion without any kind of error before the petty jury, well, the conviction after a fair trial is basically going to moot or cure any error that would have occurred in the grand jury, and so there really is no right that can be remedied because the trial itself has remedied it. But for nearly every other kind of error that can occur in a trial court, there's a separate question between whether there was an error and what the remedy ought to be. If there was misjoinder, was there misjoinder, and if so, what should an appeals court do about it? If the trial court failed to grant a severance, was that an error? What should the appeals court do about it? If the prosecutor commented on the defendant's failure to testify, same thing. A violation of Rule 11 in taking a guilty plea. A jury instruction that is argued to be erroneous, misstating the law to the jury, denying a defendant's challenge for cause for a prospective juror who is alleged to be biased against the defendant, a prosecutor's failure to turn over Jenks material, witness statements at the conclusion of direct examination. all of these kinds of errors and all of the other rules that we've studied this semester, they're all a two-step inquiry in the appeals court. Was there an error? And if so, what should the appeals court do about it? Now, what this means is that this question about remedy, what should an appeals court do about an error that it has found to have occurred, that's a values question, like so many that we've looked at this semester. What the appellate court, even if it's not doing this at the surface, what it's asking itself in a way is, what are we trying to accomplish? We basically can do one of two things. We can affirm a conviction or we can reverse a conviction. Those are the remedies that we have at our hands. What would a reversal accomplish? What values in the adjudication process would be advanced or protected by reversing a criminal conviction? I want to take a very brief historical detour just to let you know that long ago the rule was not what I've just said. Long ago the rule was that any time an appeals court found an error in the trial court, the result was a reversal of conviction. So in this rape case from the state of Missouri back in 1908, the indictment charged in its language that the offense was committed against the peace and dignity of state. But the statute required that all indictments had to conclude with the language against the peace and dignity of the state. So the defendant claimed on appeal that this omission of the word the was a violation of his rights and should require the reversal of the rape conviction. The appeals court looks at this and says, you know what? Down here in the bottom left-hand corner of the screen, yeah, it's a little word, it's just a definite article, but it's absolutely essential in order to designate the particular state against which the offense is charged to have been committed, and therefore judgment reversed. Now, you can ask yourself, what is going on here? What might possibly be advanced? What value might be advanced by reversing a conviction because the indictment omitted the word the? I suppose you could trump up some kind of argument about notice, that the defendant needs to be put on notice of which state the rape is alleged to have occurred in, but honestly, the only value that's really being served here is a value in, I don't know, grammar or something, and it's hard to see how it makes sense for an adjudication process to be furthering grammatical purity by reversing criminal conviction. Well, as you know, that rule of automatic reversal for all errors did not survive. And in fact, by the middle of the 20th century, the federal system had come around to the rule in Rule 52B, which says any error, defect, irregularity, or variance that doesn't affect substantial rights must be disregarded. And that's very helpful, right? It says that there's going to be some kinds of errors that can be ignored by a court, that don't need to be remedied. But it leaves a lot of questions unanswered. First of all, does this rule in 52B, does this apply to all kinds of errors? Or should there be a different rule for constitutional errors as opposed to non-constitutional errors? What is a substantial right? What makes a right substantial? And how much of a connection does there need to be between the error and the verdict in order to say that the error has affected substantial rights? So lots of questions are left unanswered by this otherwise helpful Rule 52B. In the federal system, the Supreme Court made clear, actually I should say for all courts, the Supreme Court made clear back in Chapman versus California in 1967 that there is a different rule for constitutional errors, a rule that's more protective of defendants. That rule says that once it finds an error, an appeals court can affirm a conviction only when it appears beyond a reasonable doubt that the error didn't contribute to the verdict that was obtained. For non-constitutional errors, in Katiakos against United States back in 1946, the Supreme Court settled on a slightly looser standard. And by looser, I mean one that's a little bit more protective of the conviction and a little bit less friendly to defendants. It says that if an appeals court finds that a non-constitutional error occurred in a trial court, it should affirm the conviction if it can conclude with fair assurance that the judgment wasn't substantially swayed by the error. So you can see these are a little different. The constitutional rule requires reversal if there's at least on its face, it requires reversal or promises a reversal if the error simply contributed to the conviction, whereas for the non-constitutional rule, the error needs to have substantially swayed the jury to convict. But one thing to notice about both of these formulations is that they are requiring the Court of Appeals to focus on the likely impact of the error on the jury's decision to convict or acquit in this case. At least in theory, these tests are not supposed to be requiring appellate courts to look at whether the appeals court itself thinks that the evidence that the prosecution presented in the trial was so strong that any reasonable jury would convict. Now, that last point that I made might seem like a little bit of an arcane distinction, so let me give you a hypothetical case that will show you the difference between these two things. Think about a case, a trial, in which the prosecution presents very strong evidence of the defendant's guilt. Some forensic evidence, calls a bunch of eyewitnesses, and so on. And also imagine that the defendant chooses to take the stand and testify in his own defense at the trial. And then imagine that the trial court tells the jurors, before they deliberate, that they should weigh the defendant's testimony with special care, because a defendant, unlike any other witness, faces a unique risk of criminal conviction and incarceration. Well, we know that that instruction is error, right? We talked about this when we talked about the defendant's right to testify and the defendant's right not to testify. It would violate the defendant's due process rights and impose a cost on the right to testify to instruct a jury that they should treat a defendant's testimony differently from that of any other witness. I should say more skeptically than that of any other witness. So an appeals court is going to conclude that an error has occurred at this trial. Well, what should it do about it? Should it reverse the conviction? Well, can we say beyond a reasonable doubt that that error didn't contribute to the jury's decision to convict the defendant? Probably not. Because hearing the judge basically say that the defendant is likelier than any other witness to be lying would lead an average juror to view the defendant's testimony, the defendant's version of the events, skeptically, without regard for what they thought of all of the government's evidence. But on the other hand, if the question the appeals court considers is whether a reasonable, properly instructed jury would have convicted on all of the evidence that it heard, that's different. It's a subtle difference, but it's different. Because there, the focus is not going to be on what the likely impact was of this mistaken instruction on the jury, but instead on the different question of whether the appeals court thinks that on balance the jury basically got it right by convicting the defendant. Two different things. So, just to summarize, the harmless error approach, whether it be the constitutional rule of Chapman or the non-constitutional rule of Katiakos, is supposed to be on the impact, the likely impact of the error on the jury's decision to convict, not on the question of whether the appeals court thinks that on balance the evidence was so strong and so overwhelming that any jury would have convicted the defendant. But in practice, and this is an important point, in practice, regrettably, it's pretty common to find appeals courts doing the wrong thing, applying a harmless error review in that second way, looking really more at the question of whether the government's evidence was really, really strong or overwhelming, rather than looking in a more precise way at the likely impact of the actual error or errors on the jury's decision to convict. Should an appellate court ever reverse a conviction where it looks like the jury reached the right answer?